Hearing in the appeal, David Moulsdale, claiming Moulsdale Properties against Commissioners for Majesty's Revenue Customs.
Yes, Mr. Simpson. My Lord's Lady, in this appeal, I appear with my learned friend, Mr. Small, for the appellants, and my learned friends, Mr. Thompson, Ms. Roxburgh, and Mr. Anderson appear for the respondents. My submission is that the court should allow the appeal and cancel the assessment. In the alternative, the court should allow the appeal and remit the case to the first-tier tribunal for the parties, if so advised, to lead such further evidence on the appellant's intention or expectation as they may wish. First, I adopt the appellant's written case. I will speak in 4 chapters. The first concerns the statutory provisions and their interpretation. The second is the issue of European law and its effect. The third is the question of eligible time, if the court requires any submissions on that. And the fourth is the issue of the evidence and what, if anything, is in dispute between the parties, properly in dispute between the parties on the facts.
I thought we'd been told that the Revenue weren't pursuing the time point.
Yes, well, that's what I understand. I didn't know if that necessarily meant the court was happy
Oh, I see.
To leave that alone, because the Lord President rely on that as a reason for his decision. If the court is happy that that is not a matter of dispute and need not be discussed today, then and I can quite...
Myself, I don't think it's a central issue. No, I don't think you need to address us on it.
I'm obliged. The case, my Lords and Lady, concerns the supply of office premises and whether, on the one hand, the supply was chargeable to the VAT because the appellant had opted to tax those premises, or whether the provisions of paragraphs 12 to 15 of Schedule 10 to the Value Added Tax Act 1994 had the effect of switching off the option. Now, the appellant's basic case, if I can put it like this, is that it is common ground that the particular provision in Schedule 10, that's paragraph 13.4, applies by reference to the grantor's expectation or intention as regards facts, factual matters, and not as regards the legislation or how the legislation works. Now, that being so, in my submission, the only sensible way to interpret this legislation and apply it is to say that, well, if facts A, B, and C, and I'll come to what they are, obtain, then legal consequence D follows. It makes no sense thereafter to say, well, because legal consequence D follows, actually it turns out that fact C does not obtain. And therefore legal consequence D does not follow after all. The reason it is appropriate to limit the inquiry to factual matters is the complexity of this legislation. And so therefore, in my submission, it is fair to make a determination of whether paragraph 13.4 in particular of Schedule 10 applies by reference only to, in this case, the appellant's knowledge of factual matters. And therefore, the appeal should succeed. The first chapter then is statutory interpretation. If I could take the court to the statutory provisions that we're looking at. They begin in the core volume at page 433. 433. I should, of course, say that I'm assuming that the court is perfectly familiar with the basic proposition of VAT law that...
Yeah, we've all sat on quite a lot of VAT appeals.
In the normal case, the supply of land and buildings is exempt from tax. An owner can opt the land and buildings.
Is that the case? If your business is buying and selling land, is that still exempt from tax? Or if the land is, if parcels of land are your stock in trade, as it were, does that make the supplies taxable, or are they still exempt?
No, they're still exempt. The difference is, of course, that if land is your stock in trade, then it is not within the capital goods scheme, because you are holding it solely for the purpose of selling it as part of your business. Yes, the position is that any supply you make of development land, I suppose, is exempt supply, unless, of course, for example, if what you are supplying is a new commercial building, in which case there are particular rules that make that a taxable supply if it's within 3 years of construction. But the basic proposition remains that the supply is exempt, even if land is your stock in trade. So, a taxable person can opt to tax any supply that he or she makes of a particular, specified piece of land or building. What paragraphs 12 and following of Schedule 10 do is switch off that option to tax in certain cases, so that the supply reverts to being exempt. Paragraph 12 on page 433.
Just before we go on,
Yes.
Can you just give me a sort of simple vanilla example of why a landowner would want to opt to tax? I mean, on the face of it, why on earth ought excise shouldn't have tax levied on a transaction? Since it has to, if it's, for example, a sale to an end user, it comes out of what the end user is going to be prepared to pay you.
Yes, Lord, but the reason for opting to tax is in particular to be entitled to get credit for the input tax.
Yes.
On supplies received, for example, in construction, refurbishment costs, or whatever it might be. But if it's, for example, an existing building where the owner has had to pay that, whether in its purchase or on repairs, maintenance, refurbishment, etc. The owner may wish to opt to tax so that, for example, if the owner is letting it out to commercial tenants who are themselves operating taxable businesses, the owner can get credit for its input tax without prejudicing its tenants, who are in turn able to proclaim the input tax they pay on their rent against their outputs in their taxable supplies. To their customers.
So if you buy land under an exempt supply, so you don't pay any input tax on it,
Yes.
you then opt to tax it. But if you're then just running a business on it, with inputs and outputs from that business, I see. So it really works if you then lease the land and
Yes.
you want to.
Yes, well, that's one example if you're leasing the land onwards. If, for example, I suppose the business is out of farming and the intention is simply to work the farm, then in that case, I doubt there would be any reason to opt to tax the land.
Because there's got to be a transaction with the land.
Exactly, exactly. The only purpose is if one is anticipating making some sort of transaction with the land. Perhaps it's worth identifying at the moment then a sort of simple scenario that these provisions are designed to prevent before I go into the detail of them. The basic idea, again, it's common ground, is that the purpose of these provisions is to preserve the basic rule, or the basic principle of that law, that a person who operates an exempt business, for example, a bank or an insurance company or a university, should not be able to get credit for its input tax. So if an insurance company buys an office building that's been opted to tax and has to pay VAT to the owner to buy it, the insurance company should not be entitled to get credit for that input tax because the insurance company's supplies are all exempt. But of course, corporate groups can be organized in different ways, and with or without any VAT avoidance motives. For example, a corporate group can organize itself so that its trading activity is in one company and its property, its office premises, are owned by a different company. And that can be for the normal commercial reason of protecting each of those, the trading activity on the one hand and the office building on the other, from liabilities arising from the other. So, for example, the insurance company, let's say, is a group of two companies. one company owns the property and the other carries on the exempt activity of insurance. Now, if the group wishes to buy a new office, it's the property-owning company that buys the office and then leases it to the trading company. Now, if we suppose that the previous owner had opted to tax the building, when the property company buys the building, it pays VAT to the previous owner. If the property company then opts to tax the building, it charges VAT to the trading company on rent. One sees immediately that the property company is operating a fully taxable business. And so gets to recover its input tax immediately. And now it charges, of course, VAT onwards to the insurance company that therefore does incur VAT, but over a longer period and in potentially a smaller amount. Which is contrary to the basic point that an exempt business should not get to recover its VAT or spread its VAT, input VAT, over any length of time. So in that fairly basic scenario, these provisions will switch off the property company's option to tax.
So it will still have to have paid the output tax to the previous owner, but
yes,
it can't, the input tax,
yes.
But it can't then charge VAT on the rent to the insurance.
That's right, and moreover, it doesn't get to claim its input tax back from HMRC because the property company is now making only exempt supplies. So in that basic scenario where there's no tax avoidance, it's simply the commercial division of the group's activities between a property owning company and a trading company, these provisions will apply to switch off the property company's option to tax, returning us to the position where the exempt business as a whole, in regards to the business as including both the trading aspect and the property, the exempt business as a whole does not get to recover its input tax, which therefore simply stays with HMRC immediately. So, now I go to the provisions. Obviously, they are rather more complicated than is needed to apply to that sort of basic scenario. We start at paragraph 12 of Schedule 10, which is on page 433. Paragraph 12, subparagraph 1. A supply is not, as a result of an option to tax, a taxable supply if A, the grant giving rise to the supply was made by a person who was a developer of the land. We'll see that the term developer is not used in any sort of normal way. It is specifically defined need not have anything to do with development.
Well, that's your case, but that's one of the questions, isn't it? Whether actually the fact that there's supposed to be a developer of the land, and that is a word which has a meaning, affects the way one construes the definition provisions of that term.
Yes, my lady, and I'll come to that, but my submission in short is that the statute in paragraph 13 goes on to define in quite specific terms when a grant is made by a developer of land, and it doesn't indicate that there's any need for the grantor to have been a developer, to have done any development of the land. But if I may, I'll come back to that just in a couple of minutes when I get to that provision.
I can't put my finger on it, but I have a rather vague recollection that there's authority to the effect that even where you have a specific definition in statute, you can still have regard to the ordinary meaning of the term being defined, as if you're in doubt as to how to interpret the specific definition, the ordinary meaning of the word being as an English word can be of some relevance.
Yes, well, one case that springs to mind in my own experience is a case of O'Donnell against MacDonald in the Inner House of the Court of Session, which was all about whether grazing land had been let out for agricultural purposes, and it had been let for the purpose of grazing horses. The specific definition in the Agriculture Act, I'm sorry, I can't remember the citation off the top of my head. The specific definition in the Agricultural Holdings Act included grazing as something that counted as agriculture. But then Lord Justice Clark, I think it was Lord Justice Clark Gill, who obviously had some expertise, said that, well, that was all very well, but because he used the word agriculture, that informed how one would approach the specific definition of grazing in that case, for example. In my submission in this case, it's quite clear that that's not the way the legislation approaches matters, and that is because specifically a grant is made by a developer. It is enough if the land or building is a relevant capital item in the hands of the grantor, and is within, and the supply has been made within 10 years of the first time the grantor began to use the land or building as the way the legislation works through. So all that is required is that the owner has bought the building and paid VAT on that purchase price for more than £250,000 within the past 10 years.
Why does it use the word developer then? Why doesn't it just say purchaser?
Well, lady, I'm not. I suppose the answer is I don't know why the word developer is used. In a sense, my submission is that the statute could just as well have said, if the grant given rise to supply was abracadabra, and abracadabra means made by someone who purchased the building within the past 10 years for more than £250,000. But my submission is a specific definition.
Is the reason why the label, which is then, as it were, subject to a detailed nuts and bolts definition, is sometimes of assistance in understanding the nuts and bolts, because sometimes the label tells you more about the purpose than a detailed examination of each nut and bolt?
Yes, Boyd, and it may well be that the problem that kicked off the need for these provisions was exempt businesses who were developing, who were building their own buildings, and that's why we have the word developer is used. But whereas that might be at least the main problem that was seen to exist at the time, this language was introduced. In my submission, it's quite clear that there is no need for a grantor to have done any development in any normal sense of that word of the property to meet the requirements of this
There's no
test.
need for it to have done, but is there a need for it to foresee, intend or expect that the relevant transferee, I'm jumping ahead a bit, will be going to develop the land
Well,
in an ordinary sense of the term?
in my submission, if the relevant transferee is going to develop the land by incurring expenditure that would be within the capital goods scheme, so alteration, refurbishment, etc., then yes, that can mean, if the anticipated expenditure is enough, that this grant by developer test is met. Of course, the curiosity is that it is the transferee who's a developer. So the grant by a developer test is met in that scenario if the grant is actually to a developer. So although there might be development in the scenario, it's not actually development by the grantor that satisfies the grant by a developer test.
But here, as I understand it on the facts, neither of them is a developer within the normal sense or intending to spend more money on the property. We're just talking about the acquisition price of the land.
Yes, that's right. That's right. But notwithstanding that, my lady, had the supply taken place on or before, I think it's the 2nd of May 3rd of May 2011, and therefore within the 10-year period for adjustments for the appellant, the case would clearly be within these provisions, and the option to tax would be switched off. Paragraph 12(1) goes on to set out a second test, and that is that the exempt land test is met. It's common ground that that test was met in the present case. And the issue now is whether the grant by developer test is met. It perhaps underlines the difficulty these provisions cause to note that HMRC's position up until their statement of case was actually the other way around, that the exempt land test was the one that wasn't met and the grant by developer test was. But since the statement of case, and as matters stand, what is in dispute is the grant by developer test. The grant by developer test is set out in paragraph 13, which begins on page 435. Page 435. Subparagraph 2, a grant made by any person in relation to any land is made by a developer of the land if A, the land is or was intended or expected to be a relevant capital item, and that is where the dispute focuses, and B, the grant is made at an eligible time as respects that capital item. No, we know that that second part of the test is not in dispute. So I can go to the paragraph 4. Paragraph 3. The land is a relevant capital item if A, the land, and we'll see that so far as the land is concerned, an item can be a capital item only by reference to its acquisition cost, so the amount of money that was paid for it. Or B, the building or part of a building on the land is a capital item in relation to the grantor. Now, all that means is that the grantor must have paid not less than £250,000 plus VAT for the land and or the building. The other eligible time test limits the scope of the provisions to circumstances in which the supply is taking place within 10 years of the grantor's first use of the capital item.
And in this case, we're just looking at land, not a building or part of a building on the land. Is that right? Or?
In the present case, it's office premises that we're concerned with.
Right.
So
it would be the longer list of kinds of expenditure, but the only actual kind of expenditure here is the acquisition cost.
That's right. I do pause here to emphasise, as I mentioned already, that in my submission it's plain that paragraph 3, subparagraph 3 can be satisfied without any development activity having been carried out by the grantor. And I dare say that is common ground, and in my submission quite plain on the face of legislation. In my submission, that makes the point that one can't, in this particular context, use any ordinary meaning of the word developer to colour the interpretation of the relevant provisions. Subparagraph 4 is the one on which the appellant relies and where the dispute essentially focuses. It sets out a further set of circumstances in which the grant by a developer test is met. And those are if the land was intended or expected to be a relevant capital item, if the grantor or a development financier intended or expected that the land, and I pause here to note that intention or expectation in relation to bare land itself is sufficient, or B, a building, so or B, a building or part of a building on or to be constructed on the land, would become a capital item in relation to the grantor or any relevant transferee. Now, in my submission, on its terms, the legislation is apt to allow the intention or expectation requirement to be met by reference to the supply that is being considered. And indeed, in my submission, the drafting suggests that that is the correct interpretation, and that the intention of the draftsman was that that supply could count as giving rise to the relevant intention or expectation. Not least because to exclude it would have been a terribly easy thing to do. The problem arises because the drafting overlooked the potential for circularity if, in assessing the grantor's expectation, for example, the legal consequences of the provision have to be taken into account. The appellant's submission on this, the core point, is that intention or expectation has to be assessed by reference to objective facts. For example, that the appellant has made an option to tax, that the appellant is selling the office for more than £250,000, and so on. The way the legislation works is that if the grantor intends or expects these objective facts, column A, B, and C, as I mentioned, to obtain, then legal consequence D, the option being switched off, follows. In my submission, the only...
It's a sort of counterfactual intention or expectation, I suppose you would say. Because if the consequence of having the expectation is to switch off the bit of machinery that enables one to have the expectation in the first place, it can't be a real-world expectation, can it?
Well...
On your submission.
Lord, my submission is that in what's sometimes called the parallel universe of value-added tax...
Well, use parallel universe rather than counterfactual if you prefer.
Your counterfactual is likewise fine by me. The law says, look at the grantor's knowledge of certain facts on the ground. On the basis of that, assess whether the grantor has an intention, a particular intention or expectation. Then the law says, if the grantor, on that basis, does have that intention or expectation, well, we are going to thwart it. But whether or not there's any tax avoidance going on, we're just going to thwart it. And that's the end of the matter, in my submission. And it makes no sense for the law then to say, well, now that that intention has been thwarted, and the option switched off, we will stop there because now the legal effect is the option is switched back on, and so the intention or expectation arises again, and so on. That's where the potential for circularity comes in, and my submission is that that potential is that the circularity is in fact prevented from arising because, as for example the first tier tribunal in PGPH says, and as I think is what HMRC also say in the written case, the intention or expectation is to be assessed without regard to the mechanics of how these legal provisions work. And therefore, in my submission, without regard to the effect these legal provisions have on the taxability or otherwise of the supply in question.
But you might have a case where the grantor just doesn't know or doesn't think about the paragraphs 12 and following.
Yes.
And acts in a particular way, which does reveal what their actual subjective intention or expectation was.
Yes, Maud, indeed. And that is one of the points on which I rely to say, sorry.
Well, if that's right, doesn't that give rise to the possibility that one might not get into the anti-avoidance provisions in paragraphs 12 and so on, if it's clear that the grantor didn't think that, for other reasons, VAT was going to be payable?
Yes, although that would presumably depend on some understanding of the law. And first, if I could say that the scenario of a grantor, for example, not knowing anything about paragraphs 12 to 17, or indeed knowing something about it but getting it wrong, which is not an unlikely scenario, suggests that their effects should indeed be left out of account, because otherwise their effects depend on the grantor's understanding of how these provisions work, which in my submission is a capricious way of dealing with that. So in this case, as the first tier tribunal found, as a matter of fact, the grantor, or the grantor's advisors at least, did know about these provisions, and on the basis of those, returned the supply as being exempt. Now, of course, that presupposes that the tests were met, because otherwise there'd be no reason to apply these provisions. But if one, for example, had a case where a grantor and his or her advisors didn't know about the existence of these provisions, then presumably, because of that lack of knowledge, the transaction would be returned as liable to VAT. And so in my submission, it can't, the charge to VAT on a particular supply can't depend on what happens to be the particular grantor's knowledge or ignorance, as the case may be, of the law.
Well, I mean, he must have some knowledge of the law, because the expectation in question is that the land or the buildings on the land, no, it's the land, is a relevant capital item. And without putting a cold towel around your head and working out what on earth that means, I don't see how you get across the threshold of having a relevant expectation.
Well, certainly the approach that has been taken in the first tier tribunal in the case of PGPH is to say that what the legislation is actually asking is, does the grantor have knowledge of the facts that, if they obtain, will mean that the transferee is going to have a relevant capital item, for example. And I understand it's common ground between the parties that that's the way the legislation should work. No, I mean, I don't put the first-tier tribunal decision in PGPH forward as any sort of authority, but just as setting out how the matter is approached by the first-tier tribunal. And my submission is that that is the only sensible and realistic way to approach this legislation, because otherwise, whether or not VAT is charged on a particular supply depends on the grantor's knowledge of the law. And that leads to, well, what I would submit are certainly not uniform results as European law requires, to the extent that's relevant, to the charged tax of supplies of this type. So paragraph 13.4, my submission is that on the facts of this case that is met because the grantor, that is to say the appellant, knew sufficient facts that would mean that bar these provisions, the office in question would become a capital item in relation to a relevant transferee. Just so the court has it, it's in subparagraph 5, the relevant transferee is defined, and Cumbernauld SPV, to whom the appellant made the supply, is within that definition as being a person to whom the building was transferred in the course of a supply. It's a supply by the appellant.
If the test, and I understand why you say so, can't depend upon the particular state of mind, including legal knowledge or ignorance of the grantor,
yes,
why is the whole test founded on intention or expectation at all, rather than just on objective facts? I mean, it could have said it's a capital, the land is a relevant capital item in subparagraph 2a, and at 4, the land is a relevant capital item if it would become a capital item in relation to the grantor or a relevant transferee. Why is intention included from a purposive perspective? What's it there for? What's it doing functionally?
Well, Laura, I think the only answer I have to that, and I'm afraid we will come across a number of phrases where I have a limited answer to give, is that if one accepts that at least a significant part of these provisions is directed at preventing tax avoidance, that is to say, preventing exempt businesses using structures that allow them an immediate credit to input tax, where on the basic idea of that they should not get that immediate credit, then the existence of any tax avoidance inevitably requires someone to intend or expect that things are going to happen. So the best I can come up with, I'm afraid, my Lord, is that the language of intention or expectation is there because of, I suppose, point that the provisions are perhaps directed towards tax avoidance is the best way of putting it. But as I mentioned, well, I don't know if it expressly said, it says in my written case, there is no requirement in the legislation for a tax avoidance motive or purpose to exist.
I mean, if one construes the language of intend or expect in paragraph 13.4 in a subjective sense, incorporating the subjective understanding of the legal situation on the part of the grantor, I'm just wondering how big a problem the circularity problem is. You might have a case where the grantor has given no thought to paragraph 12 and so on, and they just don't charge VAT on the supply of the land, and so they're not able to say that they intended or expected that it would become a capital item in relation to the relevant transferee in that situation.
Yes.
Is that right?
Yes.
If that was their state of mind. Now suppose that they have a state of mind that they think, I am aware of how paragraphs 12 and so on work. If I charge VAT, I'm going to be caught by paragraphs 12 and following. Why isn't their state of mind still that they do not intend or expect the land to become a capital item in the hands of the transferee?
Well, because my submission is first that intention or expectation has to be judged before one gets to the stage of applying the legislation. So
but that's what I'm questioning. As my Lord Briggs pointed out, paragraph 4 is framed by reference to an intention or expectation that something positive will happen. This land will be a capital item in the hands of the relevant transferee. So
yes.
It seems difficult to leave out of account some understanding of the relevant legal situation so far as concerns charging VAT, because that's a necessary part of the identifying something as a capital item in this context, isn't it?
Yes, well, so the first point is the grammar of the provision. So the grammar of the provision looks to the past. It was intended or expected that the land or building would become a relevant capital item for the transferee. So,
forgive me for picking you up on this, but why isn't the first point to start with the words intended or expected, which seem very redolent of subjective intention or expectation based on subjective beliefs of the grantor?
Well, I suppose one has to identify and work out how an intention or expectation is to be assessed. In my submission, one of the themes that runs through value-added tax law is that it is a tax that depends on objective factors. Off the top of my head, I don't have a particular European case that says that, but that is quite clearly a general principle of value-added tax law.
But if it was purely going to be objective factors, then, as Lord Briggs points out, it could have been just listed as a series of preconditions. If these objective preconditions apply, certain results follow, whereas the legislator has used, as I was putting to you, language redolent of subjective expectation of the taxpayer.
Absolutely. So the next point is that, yes, intention or expectation of the taxpayer, but in my submission, objectively ascertained. So in the normal way, when one is, in commercial contracts, for example, Muir, Head and Trimble against Dixon, commercial contracts are determined by reference not to what parties think of their inmost minds, but to what they do and say. And a standard technique of law is, yes, to try to ascertain what people's intentions were, but to do that on the basis of objective factors. So a person can't come on to court and say, well, actually...
But I mean, if we're going with objective factors, your client didn't issue a VAT invoice. So either because they didn't think that, for some reason, not based on paragraphs 12 and following, they thought VAT was not payable, in which case it seemed they couldn't intend or expect that it would be a capital item in the hands of the transferee, or they did think paragraphs 12 and following were applicable, and they would have the effect that VAT was not payable, and therefore, again, they didn't intend or expect that it would be a capital item in the hands of the transferee.
Yeah, so as a matter of fact, in this case, the evidence is that regard was had to paragraphs 12 to 15, and for that reason, the supply was returned as exempt. But in my submission, the question is at what point in the analysis does one assess intention or expectation?
I follow that. That's your submission. You say that you don't sort of go the whole hog, but what I'm pressing you on is, given that the language seems to be subjective, ordinary subjective language, why does one construct a sort of counterfactual parallel universe meaning of intention or expectation as opposed to a real world understanding of intention and expectation, which would bring those matters into account?
My submission is first that it on the facts of this case, it was a real world intention that the office would become a relevant capital item for the transferee. And because of that real world intention, it was realized that these provisions would therefore actually switch off.
Right. So why doesn't that mean that the real world intention is in fact that it doesn't become a capital item?
Well, because indeed, my Lord, if one then decides to assess intention or expectation at that stage of the analysis, it's not going to become a relevant capital item after all. Then the test for switching the option off is not met.
It does. So in the end, it does become a capital item in the hands of the transfer. That's the circular.
So and then people who don't understand or don't read what the provision is, but I think that one also has to look at this intended or expected. Paragraph 13 is defining these terms for the purpose of paragraph 12.
Yes, please.
And paragraph 12 is all on the hypothesis that you've got a supply of land and that land has been subject to an option to tax. So there's always going to be, whenever you're looking at 13, an objective intention to supply land which has been made in respect of which there's an option to tax. So the intention or expectation that that's going to happen doesn't really add anything to the scenario, the only scenario in which this is going to arise, does it?
Well,
if those are the only relevant objective, apart from the fact that the supply is going to be for more than £250,000.
Yes, Majesty. And I should also say that in the written case, HMRC do make the point that a further fact is that the transferee in our particular constellation will use the office in the course of its business, otherwise than solely for the purpose of selling it. So I would have to accept that that would be another objective fact that.
So in your scenario, it would have been better for the appellant to have initially given a VAT invoice to
Yes.
CSPV, charged them VAT, and then written to HMRC saying, oh, sorry, we've now realised that actually by doing that we triggered this exemption. Can we have the VAT back, please?
Yes, Lady. So in other words, if the appellant had had a worse VAT advisor than Mr. Murdoch, then the appellant would be in a better position, which, even in the parallel world of that,
CSPV would be in a worse position because they would have paid the VAT.
Well,
it depends whether
yes.
they
So
pass it back to them.
they would have paid the VAT. They wouldn't be able to get credit for it because their supplies. No, sorry. If they opted to tax, if they had opted to tax, which no one knows if they did or not, then they would be.
They weren't a taxable person, I think. So.
They weren't a taxable person. They could voluntarily register for VAT. I think. Yes, that must be right. And opt to tax. No one knows if they. At least there's no evidence as to whether they did or not. But in that scenario, with the appellant not taking advice about paragraphs 12 to 16, and therefore charging that, yes, it might turn out that subsequently the appellant realises, or HMRC realise on a VAT inspection visit, and assessments are made and returns corrected accordingly, so that the eventual outcome is that the supply is exempt, the option is switched off. But that's somewhat speculative. But the point remains, lady, that to approach this by assessing intention or expectation after the taxable person has decided that the supply is within these provisions and therefore the option is switched off, gives different results depending on the taxpayer's knowledge or advice received as to what these provisions are and how they work. Sorry, I am being reminded, but I think it is an agreed fact that CSPV, in fact, did not register for VAT at the time and did not opt to tax at the time. That's correct. If we take the court to paragraph 14 for one particular point, paragraph 14 on page 437. Paragraph 14 concerns the meaning of development financier. And one can see that in subparagraph 2, for example, a development financier means a person who, A, has provided finance for the grantor's development of the land, or B, has entered into any arrangement to provide finance for the grantor's development of the land. My submission on that is that where the legislation does require a fact of development to have taken place, then it says that specifically.
Oh, I see. So you accept that the word development there does contain some connotation of actually doing something to the land to improve it or whatever. It doesn't. It's not just a synonym for purchase of the land. I'm not sure how that would... So then a development financier would only be a subset of people who finance grants covered by...
Well, in fact, lady, sorry, I should have taken you to subparagraph 5, which is over the page on 438. For the purpose of this paragraph, references to the grantor's development of the land are to the acquisition by the grantor of the asset which consists in the land or a building or part of a building in the land and is or was intended or expected to be a relevant capital item in relation to the grantor. So even here, development is defined specifically so as to include mere acquisition. On the other hand, subparagraph 6 goes on to say that...
I imagine that if I was to ask you what on earth was the purpose of extending the inquiry to the intentions or expectations of the development financier, your eyes would glaze over even more than they did last time I asked that question. I'm not trying to say that the least bit critically, I'm just baffled as to why we should get ourselves involved in the intentions or expectations of the development financier.
Yes, my Lord. I suppose the answer is that in some avoidance scenarios or avoidance structures are sufficiently complicated that they are being driven by someone who is financing a development where the development is being carried on by an unconnected third party, and so it is, so far as one is trying to regard these provisions as anti-avoidance provisions, it's relevant that the intention or expectation of the development financier is what is intending the tax avoidance.
So what does the development financier have to know? Do they have to know that the land is land in respect of which an option to tax has been exercised? Do they have to know the purchase price of the land?
Yes, well, lady, the paragraph 13.4 doesn't distinguish between grantor and development financier as regards the sufficiency of an intention or what or how one identifies an intention that is within that subparagraph.
So it would be enough if the grantor didn't have the expectation, but his development financier did?
Yes. Yes, Lord.
Or vice versa?
Yes.
One or other of them?
Yes. And in the present case, it is the grantor that we're looking at.
Yeah.
And not the development financier.
But I mean, if that's the case, isn't that a pointer towards it being a genuinely subjective concept? Because if you're saying that it's objective and it's the same factors for both of them, but the provision contemplates that one or other may have the intention or expectation, that doesn't seem to work. Because in your case, judging it objectively by reference to your A, B, and C, they must have the same intention or expectation, mustn't they?
Well, if they are both, if they both know those facts, or ought to know those facts on the basis of an objective consideration of what they know.
But realistically, they know those facts. I mean,
yes. So, but because again, so far as the purpose of this provision is to prevent tax avoidance, it is drafted broadly, I suppose so as to encompass scenarios in which the grantor does not, but the development financier does, know of the relevant facts that lead to the intention or expectation that the land or building would become a capital item in relation to a relevant transferee.
Yes, well, the development financier might be related to the transferee, might be about to finance the transferee's development of the land rather than the grantor's development of the land.
Yes, indeed, my lady. So, for example, in the case of refurbishment, the development financier might be the one who knows that that refurbishment is going to involve the building becoming a capital item for the transferee. So, for example, if we posit a case where the grantor acquires acquires the asset and does some development funded by the development financier, but sells the asset for less than £250,000. But does not know what refurbishment works the transferee is going to undertake. And has no reason to know them. But the development financier does, for example, because the development financier is also going to provide finance to the relevant transferee. Then in that case, we can see that the development financier knows the relevant facts, or sufficient facts. The grantor does not, but the option is nonetheless switched off. Now, I don't think I need to take the court to any more provisions of Schedule 10, but I do need to take the court to the value-added tax regulations of 1995, which contain provisions colloquially described as the capital goods scheme, which are where one finds provisions determining whether a particular asset is a relevant capital item within the meaning of paragraphs 12 onwards of Schedule 10. Regulation 112 is at page 490. Page 490 of the core volume. It's paragraph 2 of that regulation. Any reference in this part to a capital item shall be construed as a reference to a capital item to which this part applies by virtue of Regulation 113, being an item which a person who has or acquires an interest in the item in question uses in the course or furtherance of a business carried on by him. So that would be another fact that would have to be known. And for the purpose of that business, otherwise than solely for the purpose of selling the item. Now, in the facts of the present case, of course, the supply, if we're thinking about Cumbernauld SPV, whether the office was a capital item for it, the supply to it was to a company of office premises which had a sitting tenant. In my submission, the appellant can be taken to know that. First, because the sitting tenant was his tenant, and second, of course, because he was a connected person to the tenant in any event.
But that wasn't the business being carried on by CSPV. What was the business to be carried on by CSPV?
Holding property and leasing it counts as a business.
It's not the optician's business, it's the leasing of the land, yes.
That's right, yes. Yes, my lady. Regulation 113 is on page 492. Paragraph 1, the capital items to which this part applies are any of the items specified in paragraph 2, on or in relation to which the owner incurs VAT-bearing capital expenditure of a type specified in paragraph 3, the value of which is not less than that specified in paragraph 4. As far as relevant for our purposes, paragraph 2 includes items of land and a building or part of a building at A and B. The type of expenditure set out in paragraph 3. A, in the case of an item falling within paragraph 2A or D, 2A is land, D is computers, which needn't concern us, is the expenditure relating to its acquisition. So the only type of expenditure in relation to land that can make land a capital item is expenditure on its acquisition.
But are we talking about land here or a building? Because when I asked you whether it was land, you said there's an office built on it.
Yes, Mary. So in the present case, we're talking about an office building.
Yeah.
But in my submission, sorry, everyone. But in my submission, the importance of this provision is that paragraph 13.4 can apply where there is an intention or expectation in relation to land. In other words, there's an intention or expectation that land will become a relevant capital item for the transferee. Now, the only type of expenditure that could make land a relevant capital item for Cumbernauld SPV or indeed any other transferee is expenditure on its acquisition.
Did these regulations predate the Schedule 10 provisions that we were looking at?
Well, lady, this particular version of the provisions or the regulations I can see has been enforced since 1st January 2011. The current version or the relevant version of Schedule 10 was enacted in 2008. I have to say I don't
All right.
I don't know.
But my understanding as to what these provisions in the VAT regulations are, don't worry about that, it may not matter, but I'm just trying to think what are these provisions doing, or for what purpose is this definition in the regulations? It
Yep.
exists independently of
Yes.
it being borrowed in Schedule 10.
Yes, Milady. So,
If I can say what my understanding is, and then you can say
course.
whether that's right or wrong, is that if you are running a business which is partly exempt and partly taxable supplies, and you buy a capital item, you can, on which VAT is payable, you have the input VAT, and you can deduct immediately a part of that in proportion to your proportion of exempt and taxable supplies. And then if over the next 10 years the proportion of your exempt and taxable supplies changes, so that, for example, you start doing many more taxable supplies, then you can go back and claim a deduction of more of that initial input tax, because now you're using more of that asset for the purposes, or it's attributable to a higher proportion of taxable supplies than it was when you bought it. Is that roughly right?
yes, Milady, that's
Right.
exactly it. In any event, my submission is that the fact that the only expenditure on land can make it a capital item for a relevant transferee is expenditure on its acquisition means that HMRC's position that 13.4 can't be satisfied by the acquisition of the item in question, it makes that submission wrong. And it may be worth mentioning, of course, that that's been HMRC's submission before the first-tier tribunal, the upper tribunal, and the inner house, and none of those three instances has accepted that submission. In fact, I think it's fair to say that the only judge who has accepted either party's submission on that particular point, or in the interpretation of 13.4, is Lord Docherty in his dissenting opinion in the inner house, who accepted the appellant's submission on interpretation, which is the same submission as I'm making this morning. As already discussed, of course, the type of expenditure on buildings which can make a building a relevant capital item is more extensive. This is acquisition, construction, refurbishment, etc. And we already know in paragraph 4 the value is a minimum of £250,000. That concludes my reading through of the relevant provisions. On interpretation, in my submission, there's no difference between the parties about the principles of statutory interpretation. Interpreted purposively and applied to the facts viewed realistically, as per Lord Machere's judgment in UBS against HMRC. Interpreted having regard to their context in light of the whole of the Act of which they form part, and if possible, they should be interpreted so as to avoid absurd, anomalous, unjust, unreasonable, those type of results.
Does this case involve a further question, which I don't think is covered within any of those general principles, that where you come across a statutory provision that appears, however you try and interpret it, to be a dog's dinner, and you have therefore to choose between an interpretation which really doesn't appear to spring out of the language, but might just make it work, or just treating it as ineffective, so it doesn't have the triggering effect which the statute provides for it to have, which do you go for?
Well, Lord, I suppose ut res magis valeat quam pereat is a principle that might apply in that context. I suppose if the question is...
You'd be looking at authorities like Inco Europe, for example.
If there's a mistake in the...
Effectively, there's been a mistake here in incorporating regulations 112 and 113 in toto, rather than less effectively the revenue submission. And we have to disregard the reference to acquisition.
And therefore, that involves saying the trigger will never actually apply to land, it'll only ever apply to buildings.
Yes, that would...
Well, unless the land qualifies for some other reason, but
It would apply to land if it was expected that they were going to spend £250,000 or more on doing something to the land, other than just buying it.
Does that make it a capital item under paragraph 113? As I understand it, if it's land, it's only the acquisition cost you can take into account.
Yes, so paragraph 13.4 expressly refers to land separately from a building or part of a building.
Yes.
I can check, but I'd be reasonably certain that any previous version of the capital goods scheme would only identify acquisition cost as being a relevant cost for land. Now, that being so, it's not just the incorporation of regulations 112, 113, indeed the whole of Part 15, as a whole that's the mistake, but it is also the express reference to land in paragraph 13.4 that's a mistake, and of course not just expressly referring to land, but expressly referring to it in a different sub-paragraph. So 13.4a, I think, refers to land, so 13.4a refers to land, and 13.4b refers to a building or part of a building. Of course, the mistake would also have, well, one may or may not argue about it, but that reflects also the wording in 13.3a, which is where the page 435, my Lord, 13.3a, which is the definition for when land is a capital item in relation to the grantor.
That still works, doesn't it?
That works.
Yes.
Because it doesn't depend on intention or expectation. But in my submission, these different features of the legislation, its wording, indicate that it was not a mistake, specifically to include land separately from buildings, knowing as the draftsman must have done that the only possible relevant expenditure on land was its acquisition cost. And in my submission, actually, if there is a mistake, it's in not making it sufficiently clear that intention or expectation is to be tested before these provisions are applied. But one could well see in my submission how the draftsman might have assumed it wasn't necessary to make that clear, because the way the legislation works is, if fact, let's simplify it even more, if A, then B. And one could quite see how the draftsman wouldn't have thought, well, hold on, if B, that means not A anymore. And if not A, then not B. But if not B, then we're back to A again. So my submission is implicit in the way the legislation works, that one doesn't revisit intention or expectation.
What I had in mind was Inco Europe, which is reported at 2001 Weekly 586, and it's Lord Nichols at page 592, and he says, it's long been established that the role of the courts in construing legislation is not confined to resolving ambiguities in statutory language. The court must be able to correct obvious drafting errors. So that's the test, if you like, obvious drafting errors. In suitable cases, in discharging its interpretative function, the court will add words or omit words or substitute words. Some notable instances are given in Professor Sir Rupert Cross's statutory interpretation, which is quoted, and Lord Nichols goes on, this power is confined to plain cases of drafting mistakes. So you may be looking that up either as I speak or over the short adjournment.
Yes, I most certainly will be looking it up over the short adjournment. Although as this is a Scottish appeal, I'm not sure if we just call it lunch. In any event, my submission on that is that if HMRC's submission is that the reference to land in 13.4a and the wholesale inclusion of regulations 112 and 113 are a drafting error, then that is not obvious. And that is because, in my submission, the legislation is perfectly workable on the basis I've set out, that intention or expectation is judged so as to decide whether this legislation applies, and if the decision is that it applies, then that's the end of the matter, and one doesn't revisit intention or expectation.
But so what is the situation then? Suppose I just buy land and it doesn't have a building on it, and I opt to tax it, and then I sell it to a developer, and it's still just land, but I know that the developer is going to spend millions of pounds building a hotel on it or something. Now, would you say, well, that my intention and expectation that they're going to spend all that money is irrelevant because that's not expenditure on land? It's not the relevant expenditure caught by regulation 113 because you can only look at the cost of acquisition.
No, that scenario in particular is brought in to paragraph 13.4 by 13.4b because that says the land was intended or expected to be a relevant capital item if the grantor intended or expected that B, a building or part of a building on or to be constructed on the land would become a capital item in relation to the grantor or any relevant transferee. So indeed, in my submission, that...
and it would become a capital item. I see. So then you can import that part of the list of building expenditure into the equation if you're just selling land to a developer.
Yes. And in my submission, that actually reinforces what I'm saying, because clearly in my submission, the inclusion of the words to be constructed on means that the draftsman identified that problem that your ladyship, or that scenario that your ladyship posited, that the only relevant expenditure on land is acquisition. But what happens if there will be a building that is not being conveyed at all, by the grantor to the developer. And the answer is that the draftsman specifically provided for that, and must therefore have realized that the reference to land in 13.4a wouldn't encompass that scenario. And special provision had to be made to do so. It's therefore my submission can't be a mistake. Because the draftsman, it may be inferred from the inclusion of those words to be constructed upon, recognized that the acquisition cost of land would be sufficient. But if in itself that wasn't sufficient, let's say it was £200,000, but there was proposed development of £300,000, that's nonetheless a scenario that should be caught and was drafted for. So, as I mentioned, in provisions interpreted purposively, what is the purpose of these provisions? Now, while I think it is common ground that there is at least an element of them that is designed to prevent VAT avoidance, it is common ground that the purpose of the provisions is to seek to uphold the basic principle of VAT law, that an exempt business should not get credit immediately and in full for input tax on goods or services the business obtains and uses in making its exempt supplies. And that is the purpose rather than prevention of VAT avoidance solely is vouched first by the fact that, as I mentioned, there is no avoidance or motive test. One sees all over the tax statutes anti-avoidance provisions that apply where the main purpose or one of the main purposes of the arrangements is to avoid tax. There is no such test in these provisions, and as I set out in the example I posited at the start, these provisions quite clearly apply where there is no VAT avoidance motive. In a standard commercial situation where a business separates its trading activity and its property holding activity into separate companies to protect each from liabilities incurred in relation to the other. Perhaps the best noting of that in the case law is Lord Justice Chadwick's discussion in the Principles of Newnham College case in the Court of Appeal, which is at page 859 of the core volume, page 859. That case involved the construction of new library premises by Newnham College and a structure by which it was intended a subsidiary company of the college should be able to claim credit immediately and in full for the input tax incurred on the construction. The case turned on whether, in the circumstances, the college was in occupation of the library. The Court of Appeal and the House of Lords held that it was not. In giving his judgment in the Court of Appeal, Lord Justice Chadwick, at paragraph 29, set out that it's clear that the object of the restriction, at the bottom of page 859, paragraph 29, the object of the restriction is to preserve the basic principle that an exempt business should bear input tax on supplies made to it by being denied the opportunity to treat that tax as allowable tax, giving rise to a VAT credit. And then the restriction in what was then paragraph 23AA seeks to achieve that object by denying to an exempt business the option to treat the letting of a building which it will continue to occupy as a taxable supply. That appears from reading of that provision in context. The legislative history illustrates the difficulties encountered by the United Kingdom government in promoting legislation which achieves that object, that is to say, of preserving the basic principle of VAT, without giving rise to unintended consequences, but it doesn't throw light on the question the court has to determine. The task of the court is to interpret legislation which has been enacted, having in mind the object for which it's been enacted, but recognising the extent to which that object has been achieved in the particular case must depend on the legislation itself. The court can't go outside the legislation. It must accept that if the legislation fails to achieve that object in the particular case, that must be assumed to reflect Parliament's intention that it wasn't necessarily appropriate to do so. Of course, my submission is that the corollary of that is the legislation goes beyond the achievement of the object that was intended, which is, as I understand it, what HMRC say the appellant's interpretation does. That must simply be assumed to reflect Parliament's intention if that is what the language is to be interpreted as meaning. So, despite my submission, what is a theme running through HMRC's written case, that these provisions in Schedule 10, paragraph 12 and following, are aimed at preventing VAT avoidance. Their terms clearly apply regardless of any avoidance intention, purpose or motive. And that is something that HMRC recognise in the relevant manual. The references are set out in our written case. In their written case, HMRC somewhat shy away from their manual, but I would submit that it's quite clear the provisions apply to what one might call plain vanilla commercial situations. In my submission, standing back and looking at the provisions generally, they are drafted broadly, and their history has been of an ever-broadening scope. I'll take the court only to the original provisions to make that point, which is at page 487 in the core volume, page 487 in the core volume. It's the VAT and value-added tax buildings and land order of 1994. Paragraph 2 amends Schedule 10 to the Value-Added Tax Act 1994 by inserting in particular a new subparagraph 3A. So the provisions that are the original version of the ones we're currently looking at are set out in full in, I think, 5 lines. If your lordships and your ladyship have that, 2A Roman 2, there should be inserted in Schedule 10, 3A, subparagraph 1 above shall not apply, and subparagraph 1 at that time was the provision that provided for an option to tax, meaning that an otherwise exempt supply would become taxable. In relation to a grant made on or after 30th November 1994, if A, the person making the grant and the person to whom the grant is made are connected persons, and B, either of them is not a fully taxable person. Now, by way of example, it's quite clear that the legislation now covers situations where the person making the grant and the person to whom the grant are made aren't connected, such as in the present case. Because...
So wait a minute, 3A was saying that if either the person making the grant or the person to whom the grant was made were making a mixture of taxable and exempt supplies, so is that what not being a fully taxable person means?
Yes. Yes, ma'am.
That the option did not apply?
Yes. Yeah, so at least the focus of that has changed to be on not whether either of them is a fully taxable person, but on whether the premises are being used otherwise than for fully taxable purposes. So that focus has changed. But as far as A is concerned, it was necessary for the grantor and the transferee to be connected persons. Now that's no longer necessary, for example. In my submission, one can trace this through the subsequent versions enacted by Section 37 of the Finance Act 1997, and then the VAT Buildings and Land Order 2004, to the current form of the provisions which was enacted in 2008, as a gradually broadening provisions. In my submission, that's consistent with the notion of interpreting these provisions to include rather than exclude the scenario in the present case, so that they encompass the scenario in which the grantor's intention or expectation arises from facts relating to the supply that we're looking at, the supply in relation to which we're deciding whether the option to tax is switched off or remains applicable. HMRC, as I understand it, their submission is that actually in the appellant's interpretation, the provisions are too wide. Now that's, I suppose, an odd submission for HMRC to make.
Well, I think that cuts both ways. It's rather odd for the taxpayer to be arguing that an anti-avoidance provision applies to him.
Well, my submission is that although...
It's unusual.
Yes, although perhaps there is an aim of these provisions to attack avoidance, their actual purpose is not, or the way they work has got nothing to do with tax avoidance. It's simply they apply to sets of facts which can obtain also in perfectly commercial transactions. It is indeed something of an oddity. I suppose the taxpayer's position is, of course, that the provision should be interpreted widely, and the consequence is there is no tax on the supply.
This group of sections is headed anti-avoidance.
Indeed, my lord, and that is where one gets the notion that they are anti-avoidance provisions. And I could accept a submission that if there were some sort of ambiguity that could be resolved by reference to a heading referring to anti-avoidance, then it could be so resolved. But in my submission, that's just not possible in these provisions, because the way they're drafted, that means that their application simply does not depend in any circumstance on whether there is a VAT avoidance motive or purpose of arrangements. There is no, in contrast to so many other anti-avoidance provisions in the tax code, there is no requirement, as I've said already, for an avoidance purpose or motive in these provisions. That also my submission undermines what I understand to be HMRC's submission, that it's difficult to identify an anti-avoidance purpose in the appellant's proposed interpretation. First point, the legislation doesn't look at avoidance. Second, even if it does, the point of anti-avoidance legislation being drafted broadly is so that it is future-proofed. It covers, hopefully, or the intention is that it will cover all sorts of clever ideas that tax advisors might come up with at some point in the future, because it's not fair that just because HMRC hasn't thought of a particular scheme now, the legislation shouldn't cover it. So indeed, HMRC's recognition in their written case that one can't anticipate, one can't, paragraph 85.2 at page 109 of the core volume, one cannot ex ante envisage all the products of intellectual effort that may be directed to tax avoidance. In my submission, that's why anti-avoidance provisions, so far as these are drafted broadly and are interpreted broadly by the courts. No. I think that's all I want to say about statutory interpretation in general. One can see a number of the points I made reflected in the first-year decision in PGPH by Judge Falk. But I don't think I need to take the court to that, not least because it's only a first-tier tribunal and therefore not authority. So I turn now to my second chapter, which is European law. It is for the first time in these proceedings in their written case that HMRC refer to European law as justifying or leading to a conclusion on the interpretation of these provisions. And my first point is that it's too late to raise that now. My second point is that I suppose ultimately what HMRC's submission is that the option to tax provisions are permitted by, or were permitted by European law to be made by member states subject to various limits. One of those is that the domestic provisions must ensure the correct uniform and straightforward application of the law, and another is fiscal neutrality. I understand HMRC submissions to be that if the appellant's interpretation is correct, then these limits on the United Kingdom's discretion were breached. Therefore, the provisions would be invalid under European law, but because there's another possible interpretation which HMRC says does not breach those limits, that interpretation must be preferred. And I now confess that it was not off the top of my head, but in this point that I recalled and looked up the maxim ut res magis valeat quam periat.
Which means?
I think it's preferred to be valid than to be invalid. So that if one possible interpretation allows the statutory provision to be valid, then that is to be referred to another possible interpretation that means it is invalid. It's common ground that those limits do apply to the United Kingdom's discretion in legislating for the option to tax and limits on its application or its scope. In my submission, however, HMRC have not identified any breach of those limits that arises because of the appellant's proposed interpretation of paragraph 13.4. I suppose before that I make the point that in my submission HMRC's proposed interpretation of simply leaving out the capital item created by the supply itself is not a possible interpretation of 13.4. There is no warrant for that in the legislation, and certainly no judge so far has accepted it. I submit for that reason. Second point, that there must be correct, straightforward, uniform application of the law. Well, the provisions are undoubtedly complex, but there is nothing in the appellant's interpretation identified by HMRC that jeopardizes any more than is jeopardized by these complex provisions the correct, straightforward, and uniform application of the law. Indeed, my submission is that the appellant's interpretation supports the uniform application because it means that it does not depend on actual understanding, whatever that may be, right or wrong or absent, of the grantor as regards how these provisions work. fiscal neutrality, of course, the version of fiscal neutrality is relied on. Fiscal neutrality can mean different things in different contexts. The version relied upon by HMRC in the present appeal, as I understand it, is the principle that supplies by taxable persons in the same situation as each other, in competition with each other, should be treated in the same way. I don't see any breach of the principle of fiscal neutrality. Taxation depends on whether the option to tax applies or not. That must be within the principle of fiscal neutrality, not least because it's recognized as a possibility by the directive itself. And so the difference between someone whose option applies and someone whose option is switched off is not such a breach as would take the provision outside the scope of the United Kingdom's discretion. In short, in my submission, HMRC do not identify any difference in the VAT treatment of a supply by people in the same position in competition with each other that, on the appellant's interpretation, breaches fiscal neutrality. That's all I want to say about European law. As I mentioned, I won't say anything about the eligible time requirement, so I'll move to my final chapter, which is the factual issue. This came to be controversial before the upper tribunal. If the factual issue, the evidential issue arises if and only if the court accepts the appellant's proposed interpretation of paragraph 13.4. And that is whether the evidence before the first-tier tribunal was sufficient, if that interpretation is correct, to allow this court to conclude that the test in 13.4 was met and the option should be switched off. Now, I should mention that in the past few days, following discovery of certain email correspondence between counsel, it's now accepted by HMRC that Mr. Murdoch's witness statement was part of the evidence before the first-tier tribunal.
And that's including the correspondence exhibited to it?
Yes, Lord. Yes, Lord, because in that evidence he speaks to various letters, and therefore they are also accepted to have been in the evidence.
And you're using, when you say it's part of the evidence, you're using the word evidence in its conventional sense in relation to a trial.
Yes, yes, Lord. So, as opposed to a broader sense that includes material, for example, that is before the court in the context of judicial review, but which hasn't been spoken to by any witness.
So this point arises if we partly accept HMRC's case and partly accept yours, in that we accept that you can look at the VAT bearing expenditure which comprises the acquisition costs.
Yes.
But we don't accept that you only look at entirely objective factors such as the fact of the option to tax, the fact of the price being more than £250,000, but we're looking for some more evidence, either about different things or about what the intention or expectation was with regard to what would happen to the land in the hands of CSPV.
Yes, Lydia, if HMRC's submission is that, yes, one has to take into account, for example, the fact that the supply was treated by the appellant as an exempt supply, my submission is that on the evidence, one can see that that was because, and the first tier tribunal recognises this, that was because Mr. Murdoch, advising the appellant, considered paragraphs 12 and 17, and on the basis of the appellant's intention or expectation, took the view that paragraphs 12 and 17 had the effect that the option was switched off. Yes, and so that then leaves the question being at what time does the intention or expectation get ascertained, or if one wants to go a slightly different way, does one take into account any changes to the intention or expectation brought about by the effect of the legislation? As I mentioned in my submission, the latter makes no sense because then one ends up in an endless circle, not knowing what the result is. My first point is that before the first tier tribunal, as the first tier tribunal states, paragraph 3 of its decision at page 183 of the core bundle, so that's not the right page. Sorry, the right page is page 187. Sorry, page 187. Paragraph 3 at the bottom of that page, the parties agreed that the sole issue for determination by the tribunal was interpretation of the relevant provisions of Schedule 10 of the Value Added Tax Act because they omitted the circularity clause thereby. In my submission, although the first tier tribunal in the event went on to look at actual issues and didn't decide terribly clearly what the issue of interpretation was, or the answer to that issue. In my submission, it is quite clear that the approach the parties took to the hearing at the first tier tribunal was that if the appellant was right on the issue of interpretation, the appeal would succeed, and if HMRC were right on the issue of interpretation, the appeal would fail.
And the facts, the statement of agreed facts set out there in paragraph 2 doesn't say anything about anyone's intention.
That's right. That's right. But as I mentioned, of course, the statement of agreed, Mr. Murdoch's witness statement was part of the evidence, and there was no cross-examination of it. It was not challenged, therefore. And so in my submission, factual assertions in that and in the correspondence can be accepted as vouching as proof of what they say.
And I'm sorry, can you remind me where we find the statement?
The statement of agreed facts,
No, the witness statement by, I'm sorry, the letter, is it by... No,
it's a witness
the witness statement, isn't it, by Mr. Murdoch?
sorry, the witness statement is at, well, the relevant paragraphs, the reference to 3 letters are at page 322. and the references to the letters in paragraphs 7 and 8. So, sorry, my screen's just gone a bit funny, I'm afraid. That witness statement in paragraph 7 and 8 refers to 3 letters, one of the 26th of June 2016, which is at page 284, one of the 21st of September 2016, at page 291. Sorry, I'm leaving.
1st of June 2016 is where?
At page 284.
Sorry, where do you see, where do we find a reference to the letter of the 26th of June?
21st of June.
Oh, 21st of June, yes, I
21st of
got
June.
that. And then the next one?
21st of September 2016 at page 291. And the third is 22nd of December 2016, which is at page 296. Now, my lords and my lady, I have 1 minute left, so I will take the court quickly and briefly to the third letter. The third letter at page 296. It is a letter by Mr. Murdoch to HMRC. At page 296 is a heading Facts of the Transaction. These include that the property was opted by the seller, in the second bullet point. And the third bullet point, that the property was sold subject to an existing tenancy agreement. The last bullet point, the property was expected to be a capital goods scheme item for the purchaser. Obviously that describes a state of mind that's based on some understanding of the capital goods scheme.
Well, it can't have meant that it was actually going to be a capital goods scheme item for the purchaser, because they were not a taxable person.
Yeah, I suppose what it meant, well, what it meant, I think, was that there was going to be sufficient capital expenditure on the right type of asset that was going to be used in the course of the transferee's business, otherwise than for selling it, that it would be in the capital goods scheme.
The key passage is at 297 at the bottom of the page, isn't it?
Yes, my lord, I would just come to that.
Before we go to it, can I just be sure? I wrote down, I noted what you said to us as being that the revenue accept that Mr. Murdoch's witness statement was part of the evidence before the FTT. Have I got that right?
Yes.
They didn't agree anything in relation to the letters.
Sorry, well, my understanding is that as Mr. Murdoch's witness statement refers to the letters, it is agreed that the letters were also part of the evidence before the FTT.
Okay.
To my way of looking at the, you're going to come to 298, 299, are you, in just a moment?
Yes, I'll just come to that just now.
Very short moment.
That-
Yes. All right. Well, I'll defer my question till you have.
Yes, at the bottom of page, well, I suppose at the bottom of page 297, there's discussion of the condition 1, which is that the intention or expectation that would become within the capital goods scheme. Says that the sellers opted and the sale price is £250,000 or more. At the top of page 298, the second paragraph there, Moulsdale Properties, that's the appellant, has opted the property and the sale consideration is in excess of £250,000. The property is for use in the course or furtherance of Cumbernauld SPV Limited's business. And of course one also knows that there was a sitting tenant. So in the absence of any other indication, it would be for use otherwise than for sale.
He doesn't refer to the requirement in the regs that the expenditure has to be VAT bearing, does he? He just says it's enough if the expenditure is over 250,000.
Well, this is indeed where the circularity comes in.
Yes.
My lord. So because the property is opted, what Mr. Murdoch is saying is that one would expect the price to have VAT on top of it. The amount is more than £250,000 plus VAT. Therefore, if one is testing the expectation or intention before the application of these provisions, the conditions are met, the provisions apply, it turns out they thwart the intention or expectation, and there is no VAT, and so a capital item doesn't come into existence. Just briefly on that point.
So he's putting forward the case that's been your case from that date of that letter until now.
Yes. So he's
not. So this could get over the problem, if there is a problem, as to whether there's evidence that you knew about the use in the course or furtherance of the business. But he's not saying here that he thought that Cumbernauld were going to be operating some taxable supplies business themselves.
No, he's not saying that.
He would have been wrong, but he's not saying that that's what they thought at the time.
Yes. I mean, well, whether I suppose whether. Yep.
No, I just wanted to be clear.
In my submission, it's enough that there was knowledge of the option, the amount, the proposed use in the course of business, otherwise than for sale. For the avoidance of doubt, I should also mention just lastly that it's quite clear that whether a capital item does come into existence, 13.4 doesn't matter. That's because if one takes the case of refurbishment, where it's expected that a capital item will come into existence because it's expected that the refurbishment cost will be £300,000, let us say, to be incurred after the sale to the transferee. If the transferee refurbishes actually only for £200,000, so the expected capital item doesn't come into existence, the VAT treatment is not revisited. And that proposition is common ground. And so the fact that on the appellant's interpretation the expected capital item doesn't actually come into existence because in this case because of the effect of the regulations as opposed to because of unexpected outturn of facts, it doesn't gainsay the appellant's interpretation. My Lord's Lady, I'm conscious I've gone some 7 minutes over my time. I apologise for that. Unless there can be further assistance, I would close my submission and invite the Lordship to allow, and my Lady to allow the appeal simpliciter or separately to remit it to the first tier tribunal.
Thank you, Mr. Simpson.
I'm a bank.
Mr. Thompson.
I see the time is 8 minutes to 1. I'm, of course, happy to speak for the next 8 minutes, or alternatively, if the court
Gives you a
prefers.
chance to poison our minds before we adjourn.
I'll see if I can achieve that aim in these 8 minutes. My Lords, on behalf of the Commissioners, I invite the Court to refuse the appeal and thus to adhere to the interlocutor of the First Division refusing the taxpayer's appeal dated the 20th of May 2021. I would adopt the written case for the Commissioners subject to 2 minor deletions which I require to make in light of this issue that arose latterly concerning the status of Mr Murdoch's witness statement and the correspondence referred to therein. Yep. There are 2 deletions, therefore, I would make to the written case. The first is at page 118 of the core volume, and it's the deletion of subparagraphs 1 and 2 of paragraph 112. So page 118, paragraph 112, and it's subparagraphs 1 and 2. So, and plainly, I should say, when I come on to address that part of the case, I'll explain what the position for the Commissioners actually is in light of the developments. And the second passage is on page 119, and it's to delete paragraph 115. And again, rather than trying to rewrite it in submission, I'll explain in due course what the position of the Commissioners is. Lords and Lady, there are 2 essential questions which arise in the present appeal. The first is concerned with the proper construction of paragraph 13.4 of Schedule 10, and in particular what, on a proper construction, paragraph 13.4 means when it talks of an intention or expectation on the part of a grantor that the land or building would become a capital item in relation to the grantor or any relevant transferee. And secondly, what on a proper construction that then requires in terms of proof of the requisite intention or expectation. And the Court has been favoured with extensive written argument by both sides, and I certainly include the Commissioners in that respect in their written case. But as I've reflected further on the case, I'm acutely aware of the observations of my Lord Briggs in Balhousie at page 794 of the core volume, to the effect that the issue of statutory construction in that case was one which arose against the background of arguments that had become overcomplicated by significant reference to authority, European principles and the like. And the more one thinks about the issue that arises in this case, the issue of construction, in my submission, the more one will be driven back to the short point of construction, albeit one could beg to doubt perhaps whether my Lord's remarks at paragraph 5 on page 794 in Balhousie, that the provision in question in that case was simplicity itself, could be said to apply to the anti-avoidance provisions in Schedule 10. So when I come to look at the issues of construction which arise in the present case, I'll seek to do so against the background that is set out in the written case in relation to the purpose and context of these provisions. And in the course of the submissions made by my learned friend this morning, questions have arisen from the Court about what's this paragraph getting at? Why are we looking at the intentions or expectations of a development financier, for example, and so on? And for the purposes of my presentation today, what I intend to do is take this approach, that it's common ground that the purpose of these provisions, the essential purpose, is to maintain the basic principle of VAT law, that an exempt trader should not be able to recover input tax. That's the essential purpose. I would part company with my learned friend when he then says they're nothing to do with avoidance. They're headed anti-avoidance, and the reason they seek to deny exempt traders that ability is precisely to stop avoidance schemes that have that aim. So the essential purpose is, as I've just indicated, and I would characterise that as an anti-avoidance provision. So far as the substantive detail of the provisions is concerned, the point to make is this, that as I think was recognised by my learned friend, taxpayers and their respective advisors devote considerable time and attention to finding ways to avoid paying tax. That's why these provisions are so complicated, because they reflect the accumulated experience derived from the Commissioner's experience and the decided cases of the measures that have to be taken to combat avoidance schemes. For the purposes of my submissions, however, I don't intend to become involved in a detailed discussion of what will and will not constitute avoidance in any given case, but rather to focus upon the language of paragraph 13.4 having regard to the statutory purpose. And what one can certainly say in my submission about the construction that is being contended for by the appellant taxpayer in this case is that it does not accord either with the statutory purpose, because it's not being applied in a way that prevents an exempt taxpayer from recovering inputs. It's simply providing a wholly anomalous relief in this case, in the sense that the taxpayer is able to sell the property for the price which a purchaser was willing to pay, but keep all of that price rather than accounting for VAT on it. So it's not in accordance with the purpose. And secondly, it's not in accordance with the statutory language, because in my submission, as was raised with my learned friend on a number of occasions throughout his submissions, the one thing we can be sure about in relation to paragraph 13.4 is it talks about intentions or expectations on the part of the grantor. These must be subjective intentions or expectations as a matter of language, but the taxpayer presents his case on the basis that the gloss he puts on his construction is, if there is opted land and it is sold for more than £250,000 exclusive of VAT, and there's an exempt occupier, the option is disapplied. It's nothing to do with intentions or expectations in any subjective sense. It's a wholly objective test that the option will be disapplied in every transaction which meets those criteria. And that is the poisoned basis upon which I would wish to finish the submissions at this stage at 1 o'clock, that the construction for which the taxpayer contends does not accord with the purpose or the language, and I'll seek to develop those points, if I may, at 2 o'clock.
Thank you very much, Mr. Thompson. We'll adjourn then until 2 o'clock.